Now, a statement of claim must include a certain number of elements, and this is pursuant to Article 23(1) of the Model Law, or potentially any other applicable institutional rules. And these would be if these elements were not already provided in the Notice of Arbitration. So the facts supporting the claim need to be provided, points at issue, or at least those known at the beginning of the process, and the relief or remedy that's being sought. The statement of defense, for its part, should include the defense to the particulars of the claim or whatever is set forth in the claim. And it can also include a counterclaim at this point.
There are some rules published by international bodies. Examples are provided in the slides: ICC, WIPO, DIS internationally, and by some national bodies, for example the Academy of Experts in the UK or the IAMA in Australia. The rules published by those bodies are usually for use by experts referred through those bodies' own schemes, however, and they're not binding on experts at large. As a result, there is no single widely accepted procedural code or rules to be followed in expert determinations internationally. Instead, the procedure is usually agreed by the parties as part of the process of engaging an expert, and where the parties reach agreement, it is likely to be set out in the letter of instruction to the expert or in the engagement letter issued by the expert to the parties.
The last issue we will tackle is the effect of a court setting aside an arbitral award. Here there are two contrasting schools of thought on the enforceability of an award that has been set aside by the national courts of the seat of arbitration. First, it can no longer be enforced, whether in the seat of arbitration or elsewhere. Second, an example of this is the French case law. The arbitral award that has been set aside in its state of origin may nonetheless be recognized in an enforcing court, like the French court, as when the ground for setting aside an award in the place of arbitration does not in itself constitute grounds for refusal or enforcement of the award in the enforcing court.